And then we've got our last discussion on international, and I'll let you take it from here.
Great, thank you very much. Thank you to David and all of the organizers of this panel. We have the exciting topic of international legislation. I'm Donald Koshin. I'm a professor of law and also the executive director of the Law and Economics Center at George Mason University's Antonin Scalia Law School. This is an area where I've done some scholarship and have some interest, but I'm largely going to step out of the way and let the other four experts talk mostly on this topic and hope to guide the discussion with some questions. The topic, as I mentioned today, is international legislation, and the description provided sort of sets the stage for us, that in 2022, the EU Parliament adopted a resolution to introduce legislation creating minimum standards for third-party funding in the EU. While the EU has yet to submit a formal proposal to the EU Parliament and European Commission to consider, the principles outlined in the resolution highlight many significant discussion points within which the industry can identify and debate and discuss the state of international regulation of the industry. And I think that we have four experts up here who will bring both the perspective from the EU as well as a comparative perspective of the United States and the EU, and really what we can learn in both sets of jurisdictions going forward. So I'm going to introduce all of our panelists at once and then turn it over to each of the presentations. I will suggest to you that you also visit their bios, however, because I've truncated it so that we can get into the discussion. But the level of expertise, experience, and writings in this area are quite deep, and I encourage you to explore those further after our panel is through. So first up, we're going to hear from Kai Zenner, who's the head of office and digital policy advisor for MEP Axel Voss, the European People's Party group in the European Parliament. He is a digital enthusiast, as he describes himself, focusing on AI, privacy, and the EU's digital transition. Before moving to the European Parliament, he worked as a research associate at the European Office of Konrad Adenauer Foundation in Brussels. He's a member of the OECD AI Network of Experts and the AI Governance Alliance from the World Economic Forum. Currently, he's involved in the political negotiations on the AI Act, AI Liability Directive, e-privacy regulation, and GDPR revision. Mr. Zenner graduated in political science and with a Master's of Science at the University of Edinburgh, BA at the University of Bremen, and studied in law with the state exam at the University of Münster. After Kai talks, we will have Susanne Augenhofer, who's a professor of law at the University of Innsbruck, Austria, holding a chair for business law. She's also a visiting professor of law, fall 2024, this fall, here at NYU, and a senior research scholar at Yale Law School, as well as a fellow at the Civil Justice Center here at NYU. Before her appointment at the University of Innsbruck, she was a professor of law at Humboldt University of Berlin, Germany. Among many visiting positions over the years, in spring 2018, she taught at NYU School of Law, where she was a Global Hauser Senior Fellow in 2016 to 17 and 2016 at Columbia Law School. Her focus in teaching and research ranges from international contract and consumer law to fair trading, advertising law, and antitrust law, with a special emphasis on the enforcement of rights. Her current focus in her research focuses, among other things, on third-party litigation funding, as well as sustainability and contract law, and greenwashing and the impact of AI and access to justice. She currently serves as a member of the Council of the European Law Institute, as well as a co-chair of the ELI Austrian Hub, and is a member of the Advisory Group on Consumer Policy of the European Commission. She was a co-reporter of the ELI Principles on Third-Party Litigation Funding, which were approved in October 2024, as mentioned. Professor Augenhofer studied law at the University of Graz, Austria, the University Statale di Milano, the University of Vienna, and is a Fulbright scholar at Yale Law School, as well as at the Free University Berlin. The third up will be Victoria Shannon Sahani. She is the Associate Provost for Community and Inclusion at Boston University and a Professor of Law at Boston University School of Law. In addition to numerous publications, she co-authored the book Third-Party Funding and International Arbitration, from Wolters Kluwer in 2017 with Lisa Bench-Neuveld, the first book in the world on the topic that we are discussing today in particular. She also served on the Global Third-Party Litigation Funding Task Force organized by the International Council for Commercial Arbitration in Queen Mary University School of Law from 2023 to 2018. In June 2024, we sat side by side at the US Congress, where she was an expert researcher and testifying about her research on third-party litigation funding. She also holds prominent positions in esteemed organizations, including the Association of American Law Schools, the ALI, the American Society of International Law, the American Bar Foundation, the Institute for Transnational Arbitration. She received her AB from Harvard University and her JD from Harvard University as well. And then our final speaker, before we move it into an intra-panel discussion and then open it up for audience discussion as well, is Tony Seebach, who is the Joseph and Sadie Danziger Chair in Law and co-director of the Jacob Burns Center for Ethics in the Practice of Law at Cardozo Law School. He's an expert on legal ethics, litigation finance, tort law, and insurance law, and has published on these topics in various law reviews. Among his many publications, he's also the author of a casebook on third-party litigation finance, published in 2024 by Aspen Publishing. He is a member of ALI. He's served as an expert witness concerning issues of litigation finance and is the ethics consultant to Burford Capital. Following law school, he clerked for Chief Judge Edward Kahn of the U.S. District Court for the Eastern District of Pennsylvania. He received his BA from Cornell, his MPhil from Oxford, his JD from Yale, and his PhD from Princeton University. So as you can see, we have folks who are researching at the cutting edge of this matter and really both bringing that expertise from both the continent as well as from the United States. And so with that, I'm going to turn it over to Kai to get us started in our discussion. And I will just mention each speaker is going to speak for about 7 minutes in opening remarks, and then there's going to be some intra-panel discussion, and then we'll open it up to the audience for your thoughts. Kai.
Yes, perfect. First of all, thank you very much for the invitation, and sorry on behalf of my boss, MEP Axel Voss, that he couldn't make it. He is at the moment in Germany at another conference, and therefore I'm coming, both of us, especially when I'm looking around who is here and how much research you all have done on the topic. We need to underline that our, let's say, focus on third-party litigation funding, class action, representative action, and so on, was mainly in 2017, 18, 19, maybe 20. But then, as you heard, my focus became AI policy, first of all. So also for me, it's today very interesting to hear what happened actually since 2020. What I will focus on in my 7 minutes is therefore to explain you a little bit more about why we as European Parliament adopted this own initiative report, legislative own initiative report, what we are hoping for, and what are now the next steps. First of all, let me maybe start with a little bit of history to some of you, because third-party litigation funding, especially when we were writing the report, was not really something that you noticed very often in Europe. So many people were kind of questioning already back then why we are picking up this topic in particular. And the reason was that before there was a very heated discussion, so between 17, 18, 19, in Brussels about the Representative Action Directive, which came a little bit as a surprise to many, also to us, because until I would say 2016, 17, the European Union had a very, very clear point of view that class action, representative action, and other forms that are going in this direction are not really fitting in our legal system, in our history of legal approaches. But then, as you all maybe remembered, we had this Volkswagen scandal. We had not only one, let's say, case where you could argue that there are problems with access to justice, with large companies not playing by the rules, but the state or consumers not really able to get redress. And this kind of changed completely the Commission's opinion on class action, representative action, that you saw in the 2013 recommendation of the Commission, where they were very clear that it's at least something very exceptional, that third-party litigation funding is something kind of alien to our European system and so on. And then certainly in the directives that the Commission proposed in 2020, it was much more open, and actually they were introducing representative action in all European legal systems. We, it was mentioned already, so my boss and I, we are part of the Conservative Party, EPP, CDU in Germany. And for our party, it was in particular very difficult, or something very difficult to swallow, because we were forever against class action. For us, it was really something very, very bad that is not really helpful. And in particular, especially in Germany, we had just a few years before introduced something called Musterfeststellungsklage. That it's also a kind of representative action, but was rather or much more limited than the European proposals that followed a little bit later. And with all of that in mind, our group and my boss was thinking after the law was finalized that the debate should not stop there, in particular since he was not really satisfied with the solution of third-party litigation funding in the Representative Action Directive in Article 10, and he wanted to really start a debate and especially initiate deeper assessments of certain risks, of certain opportunities, and so on. This is why we in the European Parliament initiated a study by our European Parliament Research Service that was published in 2021, and then together with our own research on the topic, and back then there was not a lot of literature available in Europe, so we mainly talked with lawyers, with academia, and so on. We put together a first list of conceptual points, really focusing not in completely banning class action, representative action, also third-party litigation funding, because we understood that the majority in Europe thinks that the introduction of such mechanisms is a good thing, but to install certain safeguards in order to prevent cases like the MasterCard case in the UK, or one of my favorites, the Red Bull case here in the United States, or other cases in Australia. If you check our own initiative report, you see we define litigation funder, meaning any commercial undertaking that enters into a third-party funding agreement and which has the primary aim of receiving a return of an investment it makes by providing the funding. So really, the focus is on commercial, is on profit, which has a reason, because we as European Parliament never wanted to prevent some organizations to provide funding, or other cases, especially what we have in Germany and in Austria, cases where the state is providing some funding. In our report, I guess most of you have read it, just to summarize, we have 7 key principles, 7 safeguards. Again, as I said, all of those safeguards are going back to research in academia, to our European Parliament Research Service findings. And we as Parliament at this stage never said this is something that needs to be introduced. For example, the 60%, the cap, I came up with this number. It's not based on any science or whatever, but we needed to start somewhere. So we really wanted to present ideas and discussion points, and those 7 discussion points were authorization of funders, kind of mandatory governance approach, fiduciary duty, capital adequacy, accountability, so that certain things are not allowed, like refusing to pay adverse costs, that there are certain standards, in particular when it's coming to the funding agreement, and that there is a certain level of disclosure. With those 7 points, and I saw that I need to come to an end, We found in the end a really large majority in the European Parliament. Again, every parliamentarian was clear at this stage that this is not a final word by parliamentarians. It's really just the beginning of a brainstorming. And if I now look a little bit around, especially what happened in Europe, I think we were quite successful, because after our report, we saw a lot of organizations to look at my co-panelists to really dive into this topic or to continue their work, to publish studies. We saw a lot of lawyers becoming extremely active. And now, and this is now my final point, everyone in Europe waits for the new European Commission to come up with a study. Over the last months, a framework contractor was performing the study, and it will very likely be published in December of this year. And then, depending on the results of the study and also depending on the new commissioner, the Commission will need to decide if they are coming forward with a legislative proposal or not. So at the moment, no one really knows how it continues to play out in Brussels, but yeah, December, I guess we will know more.
Thank you. Susanne.
Okay, thank you so much to David for organizing this conference and for Center. The Center do have also a panel on international legislation, even though it's only European legislation. And I think this transatlantic dialogue is really important, but in order to have such a dialogue, I think it's also important to clarify some points. And I'm very grateful for the introduction by Kai, but the first thing I would like to mention is we are talking today about legislative responses to third-party litigation funding, but what might not be clear for the American audience is that a resolution by the European Parliament is not a draft bill. So we are not talking about a draft bill, but it was just an opinion expressed first by Mr. Voss and then adopted by the European Parliament. But the European Commission is under no legal requirement to respond to this resolution with an act, which would be a directive or a regulation. And as Kai already pointed out, what the Commission has done so far as a response to the resolution is to organize a mapping study, which means that the Commission is looking into how different member states are coping on a legislative level with third-party funding. I think this is very important to know. And of course, as it was already mentioned, right now nothing is happening in Brussels because everyone is waiting for the new Commission to take over. And the European Law Institute organized a webinar last Monday, so 7 days ago, on the adoption of the principles on third-party litigation funding. As mentioned, I was a co-reporter for those principles, and we had somebody from the Commission speaking there, and she confirmed that right now the Commission is not acting. They're in a waiting position. They're looking at the outcome of this mapping study and also for the new Commission to take over. Just to set some things clear, I think this was important to mention. The other thing I would like to stress is Kai, and we talked earlier during lunch break, said he's talking about the class action directive / representative actions directive. But I think you mentioned earlier that I also work in the area of advertising law and greenwashing. I think it would be misleading to name the Representative Actions Directive or to label it as Class Actions Directive. There are no class actions in Europe, in none of the member states. And the directive which was mentioned, the Representative Actions Directive, only enables certain consumer organizations to bring a representative action on behalf of consumers. And the new thing of this directive compared to the test case procedure mentioned by Kai, which was introduced early on in Germany, is that consumer organizations for the first time can ask for compensation for consumers. So I think this is very difficult, or at least I have the feeling from conversations with colleagues in the US, it's very difficult to understand that there are no class actions in Europe. And without class actions, we talk about a very different scenario for third-party litigation funding than in a world with class actions and mass torts. Another point, just to show the difference between the setting in the US and in Europe, is that in consumer finance or finance of consumer litigation, it's basically never ever the individual consumer who enters into a contract with a funder, but it's always an NGO, a consumer organization. So we talk about a repeated player with some sort of sophistication, and it's different from somebody who was run over by a car and needs some money to fund the litigation. So this is very different. Also, one has to stress that the Representative Actions Directive, which is the only piece of legislation which exists on the EU level, which deals with third-party litigation funding, has a very limited scope. I already mentioned the personal scope, which is disqualified entity / NGO / consumer organization acting on behalf of a group of consumers. But it's also limited with regard to what kind of violations of consumer laws have to have happened so that such a representative action can take place. But there's no legislation with regard to outside this limited scope. So when we talk later on, maybe in our conversation, and I think as Victoria will talk about it, about arbitration or antitrust law, where we also see in Europe that funders are active, it's not regulated. And there's also no competence by the European Commission to just regulate third-party litigation funding for arbitration or other commercial law settings. I think those are different areas of law where we have to have a different lens and differentiate. And another point I would like to make is we also have to be careful when we talk about litigation finance or third-party funding, what we are actually talking about. Are we talking about portfolio funding? Are we talking about direct investment in law firms? So there's a case pending before the European Court of Justice whether or not direct investment in law firms has to be allowed under free movement of capital. So we will see, we will probably get a decision from the European Court of Justice this fall or early winter. So this is also when we talk about what should be regulated or not, I think we have to differentiate between different ways how third parties can finance litigation. And to come to one point which is discussed, I think, dominantly in the US, but also in Europe, which is disclosure. I again would say we had this came up during the first two panels today. We have to ask what to disclose and to whom and when. And I think, again, this is for Europe and with a focus on funding of consumer disputes brought by consumer organizations. In most cases, the consumer organizations disclose the fact that they're funded because they think it's a sign of approval. Somebody else has looked on the claim has merits, and this is why it's brought. I mean, every consumer organization deals with limited funding, and Kai mentioned that some consumer organizations in Germany and Austria receive some funding from the government, but this is not true for all consumer organizations, and often this funding is limited. And so, for example, Volkswagen, VW, settled finally 2 weeks ago in Austria after 9 years with the Austrian Consumer Organization. And the Austrian Consumer Organization was funded but disclosed it, and without the funding, I think even after 9 years, VW would not have settled. And my time is over, but I hope that we continue our conversation.
Great, thank you very much. And David, you're next. Sorry, Tony.
Oh,
Tony.
okay. So I'm going to talk a little bit comparatively. I'm going to focus primarily comparing the European Law Institute's principles governing the third-party funding of litigation, which was published in August of this year. I recognize that it's not the only expression of efforts to regulate and to legislate for third-party funding in Europe, but I take it to be a serious effort. And I also think it's important because it explains its sources and what it's trying to respond to. It's actually, to my mind, a good sort of place to do some empirical research. I want to stress that what I hope to do in my 6 minutes I have remaining is really make a series of descriptive and analytic points, not normative points. I have views, but I really just want to talk about what I think is analytically the case about the approach to regulation of third-party funding on two sides of the Atlantic. Now, if you look at the ELI document, it focuses, as Susanna pointed out, on a particular arena of litigation in Europe, not class actions, which they don't have, but mass or collective actions, to the extent that they are allowed, primarily for the benefit of consumers in a variety of wrongs. And the goal of addressing how third-party financing affects this particular arena of litigation, which is not to say there isn't commercial litigation finance in Europe, there isn't to say there isn't insolvency litigation being financed in Europe by third-party funders, but the ELI focuses on primarily collective actions on behalf of consumers as the sort of bulk of where the activity is occurring, and that's where they think the impetus is coming for changing from the status quo, which right now is pretty laissez-faire. And they basically focus on a number of principles that they think would protect this particular arena of legal activity. I'm going to focus on two. They call them transparency, right? And to have principles of transparency, a light touch regulation encouraging disclosure of very limited amounts of information, and also the principle of eliminating conflicts of interest. And I think it's important to understand that when they recommend concretely a certain minimum amount of transparency and a certain minimum amount of protection against conflict of interests, that the bottom line there is to leave much open to private negotiation between, for example, the public interest groups or the quasi-governmental organizations that can bring collective actions and the funders. Much of it is left to contract, but some of it they ask for minimum protections, and those minimum protections are intended to ensure that the agents for the consumers are not weakened and are given a kind of balance of negotiating ability against the funders. But the minimum protections focuses on who, not what or how. So this is in contrast, for example, I'm going to do a really quick sort of summary of what you've already heard. Outside of the consumer litigation finance reform activity, which I think really, other than the discussion we had about New York, where there was some talk about concrete price controls, most of the litigation finance reform efforts in America, which focus on consumer and primarily now commercial, right, focus on using the technique of disclosure. And not just disclosure of the who, but disclosure of the what and how. You look at many of the proposals in Congress now, for example, HR 9922, you look at some of the most recently passed state laws, there is this disclosure of the actual document, which is of course not just the who, but in fact the how of the funding is going to occur, the details of the funding agreement. And I think it's interesting to ask ourselves, why is there this sort of different approach? Why in Europe, in order to protect the sort of arena that I described, collective action on behalf of consumers, there's a narrow focus on who, and why in America we have this purportedly protecting some set of interests which broadly go everywhere from class actions to individual consumers with $2,400 claims to multi-million-dollar parties. We have a disclosure regime which goes much further. It's the how and what of the actual transaction. And I'm going to just give a few ideas. Again, purely neutral. I'm just suggesting that this is what's driving these two different responses. Civil litigation in Europe and the United States are characterized by very different dynamics. The basic dynamic I think that we have to remember is the difference between the dynamic created by the loser pay rules and the dynamic created by the American rule. And I think that we should realize that under the loser pay rule, there's vulnerability on both sides of the V. The chief vulnerability is to either side, V or the plaintiff or defendant. If they lose, they have to pay the other side's costs. But structurally, if we're thinking about the arena that the ELI is concerned with, representative actions for consumers, structurally, there is a clear extra vulnerability of representative actions on behalf of plaintiffs. They are in the worst possible position to absorb adverse costs. And so I understand how TPLF might be seen as a way of helping correct what is a structural imbalance there. And what you want to ask yourself is, if we're going to have a cure, is the cure worse than the disease? And what you really want to make sure is that if you have TPLFs for consumer groups who are trying to bring representative actions, that they are protected against additional vulnerabilities, not just the vulnerability of the adverse costs, but now new vulnerabilities that might come from dealing with for-profit funders. And there, I think, the minimal requirements of disclosure of who and addressing conflicts of interest are rightly sized. I think it's a correct and proportionate response. Now, I will say, neutrally, that if the chief vulnerability in America is not coming from the loser pay rules, it comes from something else. It comes from a dynamic arising from the American rule. In the American rule, where each side pays their own costs, the chief vulnerability for either side is that the party who cannot bear the risk of the adverse party, the other side, increasing their investment in litigation. The weaker party, the one who cannot pay the extra dollar, is going to lose the case. That could be on the defense side, that could be on the plaintiff side. TPLF addresses that for plaintiffs. TPLF makes sure that plaintiffs have access, inexpensive capital, relatively speaking, to be able to pay that extra dollar. Now, if that's true, right, what I find weird about the disclosure rule, or what I find odd about how it fits into addressing how TPLF needs to be sort of guarded against, is that it's not protecting the plaintiff, it's protecting the defendant. Basically, it's giving the defendant a lot of information that helps them overcome whatever advantage TPLF provides the plaintiff under the American rule and under the dynamic of litigation under the American rule. I'm making a neutral observation here. My neutral observation is this. I'm not quite sure why we should be passing public law in order to protect defendants in this particular dynamic. If it were true that we had a flood of frivolous litigation, if it were true that we had a flood of litigation that had no merit, then I could see why we might need to use public law to help out defendants. But I don't think that's the America that I see. And therefore, that's why I kind of find it interesting and perhaps useful to understand why we have the particular protections that are being generated in Europe and the dynamic that generates that, which makes perfect sense to me, and why we have the particular protections being proposed in America, and why I don't think they're very attractive. That's my normative point. I'll stop there.
Great, thank you. And Victoria?
Thank you, Donald, and thank you so much to David and the organizers and the Center for hosting excellent conferences, of which this is only one. I encourage you all to go to the center's website and check out other events that are really, really fascinating and cutting edge. So I'll just touch on a few more areas that are interesting in comparing the US context and the EU context, and I'll pick up on some of the comments that were made by some of my co-panelists as well. The first I want to mention, which hadn't been mentioned yet so far, is the definitional question. So one of the things that's really challenging about funding, and this is true for every single body, task force, working group, et cetera, that's looked at this question, is defining funding is always been challenging, and it's getting even more challenging because funding is changing, morphing, innovating, which is exciting, and yet also poses a difficulty for regulators. So one of the things that I think the ELI principles does very well is try to come up with sort of I think a middle of the road definition that encompasses most of what we're looking at, what funding would be, but of course it's a bit over-inclusive, a bit under-inclusive, as is every other definition I've seen out there in the regulatory context or in international arbitration rules. There really is no perfect definition, and so that's one of the big questions is, can the funding industry sort of contract around definitions if the definitions can never fully capture everything that's happening? This issue came up when we did the work for the global ICA Queen Mary task force that was mentioned earlier as well. And I encourage you to read that report, which was published in 2018. It is a few years old, but it has a whole chapter on how challenging defining funding is. And I think that information is still relevant. So you can find that for free on the internet. A couple of other things I'll mention in the consumer protection space, which has been mentioned extensively, of course, already by Kai and Suzanne. The consumer collective redress question is so different in the EU than in the US that I think it's kind of like apples and oranges to compare the two. But I do think what is fascinating here is that the US context of the class action really isn't funding the direct plaintiffs. It's funding law firms. So it's a totally different way of coming at the funding than in the EU context with respect to these sort of consumer organizations that aggregate claims and bring the action. So it's the legislative intent, or at least the not legislative, because this is just principles, but the idea of addressing collective redress is coming at it from a totally different angle than in the US, and so the purposes are different. Susanna and Tony already discussed mass representation, so I won't go over that further. I did want to talk a little bit about federalism. Professor Glover mentioned federalism during one of the earlier panels, and there's a distinction there as well. Of course, as we know, the United States is a federal system. We have a federal government, and we have state governments. The EU is a little different, right? It's not really a federal government and state governments. You have nations that are sovereign and have their own independence, more so, I think, than you have in the US. And so that poses another challenge. I think that the way in which the European Parliament has addressed this and the ELI principles has addressed this is very reasonable. They're saying, let's come up with best practices and guidelines. Let's come up with sample contracting language, so you're sort of getting at it from the ex ante position rather than ex post, which is sort of disclosure. After you've already contracted, disclose, which is sort of the US way of dealing with the question. Because we don't have we don't have direct federal regulation of funding in the US yet. We don't really have as big of a federalism issue than what may arise in the future if the US federal government decides to really go deeply into regulating funding. I don't foresee that. I think at most, at least in the short term, we'll get a disclosure rule, which doesn't really conflict with any existing state laws, so I think we'll be okay. But if the federal government decides to go further into this space, we'll be curious to see what may happen. For example, the Consumer Financial Protection Bureau, which for those who may not know in the US is a sort of consumer watchdog for financial products in the US, it has asserted that it has regulatory power or at least oversight power over non-bank entities. Not fully defining what that means, there's a question about whether funding might be non-bank entities that might pose a consumer protection risk and whether the CFPB might take a further interest. No, not saying that that's happening, but it's a curious possibility. So I'll stop there with that question. The next topic I wanted to address is regulation of entry into the market. So generally, we could think about the U.S. a little bit as the Wild West, which often we do think of the U.S. that way. So pretty much any person or entity can fund a case as long as they comply with the local and state regulatory requirements, including court rules, have the money to invest, whether it's from investors or from their own pockets, and find a willing party or law firm. Now, if the funder meets certain characteristics, they may also be subject to regulation by the Securities and Exchange Commission or other regulators here in the U.S. But this means that you can have individuals who are funding, including high net worth individuals. You can have not-for-profit entities. We even have crowdfunding here in the U.S. I mean, there's a little bit of that in the EU as well. And so the regulation of market entry is really not very strict here in the U.S., practically speaking. Whereas in the principles and in the proposal, this idea of coming up with regulations is mentioned for market entry. Sort of as this idea, let's constrain the market a little bit. And I can see pros and cons to that. I think that will affect pricing. Whether the market is more open or more closed will affect whether there's variability in the pricing. Perhaps new entrants might have cheaper prices. Perhaps having the market be more closed might actually be better for prices because you might sort of tend towards a mean or a norm. I'm not sure one way or the other, but it definitely is something to discuss. And finally, I'll conclude with a quick mention about arbitration because it's been mentioned a couple of times. So the EU is more focused on regulating funding and arbitration, whereas the US regulatory context is not addressing arbitration at all. Suzanne mentioned that funding can often be a signal of the merit of the case, and that I've actually heard international arbitrators say this in conferences where when they see there's a funder, they're like, oh, this might actually be a good case. And so there's a query about whether or not this is influencing potentially the decision maker, whether that's a positive or not development. It's up to you to think about that. Tony also mentioned the loser pays rule. So in the international arbitration context, loser pays is generally the standard, particularly in investor-state arbitration and most commercial arbitrations as well, unless there's some contractually different provision. And so what's interesting about that is it creates a different dynamic when you're trying to regulate funding than in the US context where we have the each pays their own. And so I'm curious if in the US, if we change our rule or if international arbitration or other forms of dispute settlement started to tend more towards the each side pay their own rule, would that affect the funding market? Not quite sure about that as well, but something to think about. And the last thing I'll say is reference to something Professor Steinitz mentioned on the first panel. She talked about a large number of meritorious cases that are not funded because the economics aren't favorable to funders. And this could include a claim for declaratory relief or injunctive relief, as well as defense side funding, which we have not talked about at all today, but it is something to think about. In the international arbitration context, particularly in the commercial context, you kind of have a balance where you could have a counterclaim on the defense side that could be funded that then subsidizes the defendant's defense, right? And so in the commercial context of international arbitration, funding is viewed as a little bit more balanced. In the investor-state context, particularly because of the loser pays rule, the imbalance is stark. And that's where a lot of the fight is coming in. And I know that the EU is very concerned and focused on that as well. So I would just challenge all the funders in the room and those who are part of the industry to consider that if funding is really about increasing access to justice, that the funding industry should come up with a way to provide these products to declaratory and injunctive relief claims, as well as figure out defense side funding. I really think that will help balance things out and also will increase positive public perception. So I'll stop there. Thank you.
Thank you. Thank you to all of our panelists. I have one quick clarifying question for each panelist to kind of get the conversation started, and then I'll turn it over to each of you to respond to things that the other panelists have said. But I think all of these questions will require just a short response, but maybe enlarge the discussion slightly. So Kai, for you, I was wondering, and in part this is motivated by my own interest. We at the Law and Economics Center, we are focused on a lot of judicial education. So a couple of my questions are going to be focused on the judge's role in all of this. And so I'm curious, what's the level of judicial understanding of the environment in the EU of this, and what's their level of involvement in the consideration of the regulatory structure?
Yeah, it's a rather easy and quick answer on it. As I said already, back then in 2020, the Musterfeststellungsklage, so our German approach was, Susanne need to help me now, I think 1 year adopted back then, and I think it was adopted in 19.
Passed right after VW became in public
Exactly.
as a sign of the German government to do something
Exactly.
about VW.
But it was in 18 or 19, right? Exactly. So,
2018.
or 20. So basically, most of our discussions were really based on non-European feedback. So feedback from Australia, from the United States, from UK, and so on, which of course have a complete different legal system than we have in Germany, than we have in France, and so on and so on. We tried to reach out to judges, we tried to reach out to courts in general, also to associations and so on. But back then, feedback was either extremely careful, we don't have a position yet, or we haven't really tried out the new mechanism. So one example I wanted to make in relation to what Susanne was saying, back then, indeed, we had, for example, huge fears that qualified entities, so those entities that are capable or permitted to use the new directive would misuse it, and that there would be a lot of ad hoc entities. It was a fear that, as Susanne was saying, until now, it didn't really materialize. There is nothing like that happened so far. And this goes a little bit back to your question, that, the whole discussion was rather theoretical and extremely focused on events happened outside the European Union, which is why I think in the end we made a really wise decision as European Parliament, which is rather unique, to not regulate like we normally do on everything, but here really ask for more data, for more research to be done before we do something. And nowadays, I think our judicial system would have those experiences, those first cases that they could share, but back then was not the case.
Excellent. And I'm very curious and interested in the research environment and what that looks like, but I'm going to, maybe later we can talk a little bit more about that. Susanna, you said something that intrigued me, and that was that there is a tendency in order to provide a sort of validation for the cases to disclose nonetheless, so that you can project or signal to the world the quality of the claims. As far as I know, that's not generally emerging as a ethic or a culture in the United States. So can you tell us a little bit more about that and why you came to that conclusion that this is actually a validating function? And if it truly is something which is of value to the funders to make it express, then why might you speculate we don't see more of that in the United States?
So I think the background or the reason why it's so important for consumer organizations to publish the fact that a funder is used comes really from the fact that they have such limited resources and really have to decide for which case to go and which not. I mean, I talk to a lot of consumer organizations in Europe, and they're aware of way more cases they could, in theory, bring, but they have to decide which to go for just for limited resources. And I think what's different in the US is that the big cases are mostly in a commercial setting, and probably if you already have a big law firm behind you, you do not need to have this extra validation from a funder. While if you're a consumer organization and you are compared to VW, definitely the David and not the Goliath, it's more important to show that you have enough funds to go to go before court or bring the case before court, but also that somebody outside, maybe your one or two in-house lawyers in your little consumer organization, have looked at the case. So I think there's just a different setting. I cannot show you any numbers whether or not in commercial settings in Europe it's always disclosed that funding is used. So antitrust is totally different from the consumer law setting. So this might be a difference.
And more indication of the need to sort of have these discussions on in category-based things,
Yeah.
right? Because there's so much that we can talk about, and overgeneralization sometimes runs risks.
Yeah, and maybe if I could just mention, so the principles of the European Law Institute, they contain 12 principles which could be applied to commercial as well as consumer law settings, and then we have more information on different settings like consumer law settings or arbitration and so on.
And Victoria, it looked like you had a small
Yes.
point on this.
Yes, I just wanted to add, you asked about the US context and why it might be a little different in the US. And I think one of the challenges in the US, or not challenges, differences, is that we have this class action function that has a very significant class certification stage at which the attorneys in the case have to show that they are well-funded, which is a different procedural posture than the consumer organization trying to show that they're well-funded, because class counsel tends to be very sophisticated. And so we have this, and sort of that process doesn't even really involve the clients. And so that procedural piece, I think, is one of the reasons why you don't see the funding as a signal as much in the class action space. There may be other reasons too, in the US.
Great. Tony, I had a quick question for you, and that is, I know given limited time, there wasn't a lot of, to talk robustly about everything here, but when you focused on the beneficiaries of the disclosure rules in the United States, and from the neutral perspective and talking about the plaintiffs versus the defendants, there is sort of a third constituency, or probably far more than three constituencies, but a third constituency is the courts. And does that, from a neutral perspective, do you see the courts as beneficiaries of disclosure? And if so, does that need to be taken into the calculus where it may not just be about defense advantage, but instead about necessary information for the courts?
So, Polster asked for disclosure in a very important case involving opioids. There are certainly two district courts now that have mandatory disclosure to the court as well. And to the extent that the court is, as in Polster's case, I believe, and I think also in New Jersey, primarily trying to work out whether or not there are conflicts of interest that the court needs to be aware of to fulfill its own duty, specifically with regard to whether or not they need to recuse, then of course that is a genuine interest. It could be resolved easily by in-camera inspection. They're the ones who know best. However, my understanding from having looked at the arguments for disclosure to the court is that they overstate the risk of conflict of interest with the judiciary, given how little publicly traded companies there are out there, and the unlikelihood that the judge would be otherwise privately investing in a funder. And also, there is, I think, a bit of slippage here, and I want to pick a slightly different point. Sometimes the argument is that the judge needs to know because they need to know who's really on the other side in terms of settlement negotiations, as if that is a genuine interest of the judiciary. And sometimes that gets shaded into, well, the defense needs to know who's on the other side of settlement negotiations. And I actually want to interrogate that claim a little bit. I am not quite sure why that is, in fact, a genuine interest of the court or of the defendant to know who's on the other side. I mean, I understand that people think that that's why in 1971 the Rules Committee adopted the disclosure rule for liability insurance, but that's just not true. That's not why they said disclosure of liability insurance policies, to find out whether or not the insurance company, people already knew the insurance company could control litigation. So I really want to understand exactly how genuinely people think that is an interest worth focusing on.
And perhaps we'll get into that in the Q&A. I think that it would be an open invitation to others to talk about that. Victoria, my question for you before we turn to the rest of the panel. Listening to you, I realize that when we talk about the definitional issue, we're often talking about the category of funding, right? But you've raised a really important point, and that is, how do we categorize funders in the overall system, right? Like, what are funders? And what I wonder, and you mentioned the different buckets they might get placed in terms of who has jurisdiction over funders. I think both at a state level and at the federal level, that's an unclear question. And I just thought maybe I'd give you a sec to elaborate on that. And I don't know the answer to this question. Has the EU been better at putting them in a bucket? than we have? And if not, is that sort of a separate discussion that we should be having? Because I think when we have the debates about third-party litigation reform or legislation or other things, it's often this definitional issue or it's a disclosure issue or stuff, but I don't know that there's been a lot of legislation proposed or bills proposed that says, here's X agency, we want you to have jurisdiction over this.
Yeah, so thank you, Donald. Yeah, it's a really challenging question, right? Because since we don't have, to the point I made earlier about market entry, we don't have a lot of barriers to market entry in the US. So a funder could literally just be a person who is providing money to a person that they know for their case. That person counts as a funder. There is no regulatory mechanism right now that exists, unless you're in a state that requires a license, that captures that person who's a funder, all the way up to, Burford, publicly traded companies, and everything in between, private, high net worth individuals. Crowdfunding is another thing we haven't talked a lot about, but it is fascinating to see what individual people pooling their resources will want to support in terms of legislation, and in terms of cases, and there is no clear regulator. There are some state statutes that do designate a particular state agency to regulate licensure or disciplining of funding in those particular states, but at the federal level, it's really unclear. We've seen a couple of SEC enforcement actions, but that's been sort of outside the norm, and not all funders would fall under that purview. I mentioned the Consumer Financial Protection Bureau. They've come up with this non-bank entity language. Not quite clear what that really encompasses. Does it encompass a funder? Maybe, maybe not. Maybe it depends on how the funder is engaging in the market or in the case as to whether that would qualify. And then there are loads of others. So I think in the end, we are not going to come out with, here's one regulator, unless there was, let's create the agency that regulates third-party funding. I don't think anyone really wants to do that. So I think it's still going to end up as this patchwork, depending on how the funder is funding, what types of cases they're funding, what jurisdictions they're operating in, how they're organized in terms of their corporate structure, whether they have investors, what types of investors. All of these factors will come into play as to where in the regulatory landscape the regulation and the oversight will come from. But the definitional question is key. You're never going to create a perfect definition. And I think we realized that after 5 years, that the ICA Queen Mary Task Force worked from 2013 to 2018, 5 years of conversations across industry folks, government entities, lawyers, everybody. We couldn't come up with a definition that met all the needs. It was just, here's generally what captures most of what we're talking about when we're talking about funding. So to some extent, it's about a little bit of, you know it when you see it. Funders know that they're funders. Parties know when they are funded. Can we come up with words that actually describes everything that is funding? Not really. So it's a fascinating challenge.
Well, I'm sure that each of you heard something from your co-panelists that you found intriguing or disagreed with or wanted to amplify with your own perspective on. So if each of you could take the next 2 to 3 minutes apiece to sort of respond and or to pose a question to each other, I think we can start with Kai. Kai, anything that you want to respond to?
Yeah, maybe I would come back to Tony's point, because we had actually the discussion on disclosure very, very lengthy in the European Parliament, exactly because of what you are saying. Are we not giving the defendant too much information that the defendant should not or doesn't need to understand? And you were mentioning it with your second question to Tony. Basically, in the end, we came up with, so far, again, my research ended in 2020, but I still think it's a rather good approach. We came up with a two-level approach or system. First of all, we wanted to have national supervisory authorities that are, of course, not looking into every detail of every funding agreement and so on, but that are a little bit monitoring the general behavior or activities of funders. The idea was really, like in Germany, we have the saying of bad apples, so that these authorities would see if there is a certain funder that is, for example, in particular, notorious of doing very intransparent or unbalanced agreements, that is constantly violating rules of our legal proposal as European Parliament and so on. And then we wanted to give the court, indeed, so the judge, a special role, because we were thinking and hoping in the end that, well, the judge is someone you should be able to trust, that he or she is not sharing information with the defendant, but that's the judge. And again, in our proposal, we had a very clear article on how a third-party litigation funding agreement should be written, that the judge is basically taking those principles into account and, for example, is saying, in this particular case, the quota, so the final redress that the claimant is getting is too low. So I would claim as a judge that the framework of the agreement is unfair. This was our idea, so again, a more general approach, but this combined with this individual assessment possibility for the judge. Again, so far I haven't heard anything better, at least from a European perspective. I think it's really kind of balanced and is taking certain risks also into account. And maybe just a final point, because there's a lot of talk right now in Brussels about overregulation or unclear legislation. We have right now, especially in the digital field, but also in other fields, really a lot of legal proposals. And also in consumer protection, there's now talk about a Digital Fairness Act. But very often, it's more the case that existing legislation is not really well enforced. And therefore, again, going back, and I don't want to promote too much the European Parliament, but I think with third-party litigation funding proposal, we did really a good thing, and the Commission will also now see it in a much broader perspective, in particular with consumer protection, what is really needed. So now that we have 4 years of evidence, of empirical data, are certain things that Axel Voss was worried about in 2020 are really a critical issue, or like with the ad hoc entities, it's something that we were very afraid about, but it's not really existing yet.
Susanna?
I would like to come back to something Victoria pointed out, which is the different structure of the European Union compared to the US. So there are different countries, and they have something called procedural autonomy, that even though there's a directive like the Representative Actions Directive, they have some leeway in how to transpose said directive. And maybe also coming back to something which Kai said early on, that his party was always against class, or still is against class actions, representative actions, or anything group, let's call it group litigation. So 5 member states of the 27 member states of the European Union still have not transposed the Representative Actions Directive, like almost 2 years after the end of the implementation deadline, which shows you how much the angst is in Europe to have something like American-style class actions, and in combination with American-style class actions, also third-party litigation funding. So we have member states which do not allow third-party litigation funding at all, because the Representative Actions Directive, again, the only piece of legislation we have on a European level dealing with third-party litigation funding, is not forcing member states to have third-party litigation funding. There is merely one article saying, if you have third-party litigation funding and there are some doubts that there is a bad apple involved, then the judge should have the right to ask for more information with regard to the funding agreement. So this is something to keep in mind. And some member states which transposed the directive went overboard, like Germany, which introduced a 10% cap of funding in consumer litigation, which is which basically means ad hoc to funders in Germany, that no consumer dispute will be funded in Germany. So this is really different from the US. And then something else, Europe does not exist only of the member states of the European Union. A former member of the European Union is so the UK is important for litigation, not especially commercial litigation. And there we see different approaches, and so it's really a different setting. And again, coming back to what you said, we have to really make sure what we are talking about when we are talking about regulating of third-party litigation funding or not. Just one last sentence. So we were also talking about controlling the entry to the market. And while we don't have like a super agency in Europe dealing with entry to the market, we have, at least for the scope of the representative actions, kind of an indirect regulation of the entry, because the consumer organization has to be qualified before it can bring a claim, and the consumer organization has to prove that it's not influenced by a competitor of the potential defendant or any other entity or business outside, or I think they're allowed to be influenced by consumers, the consumer organizations, but that's the wording actually, but not by businesses or competitors. So there's kind of a regulation of the entry to the market in an indirect way, at least.
Tony.
So this is a question for Kai and Susanna. There's two questions. It comes from the observation, as Assemblyman Magnarelli pointed out earlier, in America or in New York right now, the concern would be in the context of consumer litigation finance for the wrongs that are being inflicted upon vulnerable individuals who are in no position to negotiate necessarily or to protect themselves. When we think about how consumers are generally represented currently under the sort of model as the ELI describes it, while there's a possibility of having one-shotters, individuals maybe getting financing arrangements in Germany even with the MyRight platform, still the emphasis, the design is focused, the gravity is around the relationship between professional, perhaps nonprofit, but still full-time consumer organizations and professional for-profit funders. And my question for both of you is, do you think, for example, that you can make a generalization about the competency of the consumer organizations who are negotiating with the funders such that we can describe as to what extent they need to be protected from anything other than outright misrepresentation and opacity? That's what I think transparency and conflict of interest as basic principles are supposed to cure, the outright misrepresentation and opacity. And the second, and then this becomes a little bit more pointed, is in the ELI report, it suggests that it's open to private negotiation between these consumer groups and the funders to give up a great deal of control over the litigation, which is something which is seen as controversial on this side of the Atlantic. And I'm wondering, do you think that's okay? Do you think it's okay for professional full-time consumer groups to sit down with professional full-time funders and even dicker over that, something as important as control?
Should I start? I will reply with a very emotional response. Especially now, as someone coming from Germany, as my co-panelist was already saying, consumer protection organizations are really strong in our country, have a long history and so on. So I would say, speaking now for almost all Germans, that there is a kind of high level of trust. You are just thinking they are really fighting for you, a little bit like an anti-corruption task force or something like that. So without commercial interest, they really care to make your situation better, and they are improving basically the wrong that you have faced. A little bit comparable maybe with the ombudsman system in Scandinavia, where I think also when I speak with Swedish people, with Danish people, they really trust this entity. If you are now talking about my rights and so on, again, at least in my circles, it's seen as something alien, as something that is not really fitting in our legal system, and therefore there is a lot of skepticism towards them. However, we saw that the old system, let's call it like this, was not always working, and therefore many consumers, like you also indicated it, are thinking, well, VZBV, so our consumer organization, will not help me against Ryanair, for example, when I have a claim, and therefore my rights, even though I don't really know what they are doing, and maybe I do not get as much as I would get in a fair process, at least I have 80 euros back, so why not? So I would say we are there really in a kind of transition period where those both approaches are now there, and there's still a lot of skepticism, but maybe companies like My Rights will win a majority over by providing faster and quicker something, because what Susanne was saying before is really true, and I was surprised. I'm now in the last years here, and they are talking with Max Schrems, who is, I think, also well known here, the guy who is fighting against Meta, and he was basically seen as one of the big, let's say, persons that is benefiting from class action in Europe or representative action. But he told me that it's way too expensive, way too unsure if he will have success, and the same, of course, for consumer protection organizations, that even in Austria and Germany do not have a lot of funding, so they have maybe 1-2 shots a year, and they need to be very, very sure that those shots are working out in the end, to say it simple.
Susanne.
Yeah, I agree with Kai that the consumer organizations in Germany and Austria have, or there's actually only one consumer organization in Austria, it's a tiny country, so have a very good reputation, and in some other member states like the Netherlands and Italy, actually they are not consumer organizations, but the antitrust authorities, so it's a different setup, it's a state authority, also have competence in consumer law cases. So we are coming back again to the differences in member states. We are not always having consumer organizations, but sometimes we have agencies. But I agree, the reputation is very good, and I think when one question was about giving, I think Donna's question, sorry, you said, is it okay for
Yeah.
consumer organizations or agencies
give away control.
to give away control? I think it's never okay, but I'm also not believing in fairy tales. So I'm not believing that the funder is not interested in what the outcome, obviously it's the job of the funder to be interested what the outcome of the litigation is. So agreements are not published, so I don't see what's in the agreement, but I assume that there's some trade-off between getting funded and having to give up control. And then something which I forgot to mention earlier, and maybe it's clear to everybody in the room, but why not mention it? I'm a professor, so I'm allowed to make, to try to explain things. There are no contingency fees in Europe. So I think this is also something which makes it more important for consumer organizations or Max Schrems to get funding, and why it's so difficult to bring cases before court. It's just very costly if you have to pay your own lawyer up front. And then with regard to My Right, maybe again, it's clear for everybody here, but we're talking here about a business model where the business one is called MyRight, gets assigned the claims of the consumers, or in the case of MyRight, not only consumers, but everybody who ever experienced a delayed flight in Europe knows that there's a regulation giving you compensation depending on the duration of the flight and the kilometers flown. And it's actually very difficult for the individual to convince the airplane to get the money, but it's very easy if you have the legal deck which shows whether the weather was nice or not that day, because that's usually a claim made by the airplane. The weather was bad, it was snowing, it was raining, everything at the same time, and this is why the flight was delayed, which would mean they would be exempted from having to pay. And do I think it's good if such businesses get 30% of my 250 euros? No, but is it better to get nothing? As Kai said, yes. And I don't believe that funding, whether is it through MyRight or in a more, bigger settings, is legal aid. So if there would be legal aid for every case, perfect, but we have to live with what the world exists with, and I think then it's better to have something like MyRight, and they get 30%, but I get 250 euros minus 30%. And last point, because MyRight is one of the very few examples where consumers in Europe have direct contracts with kind of a funder. Again, what is MyRight a funder? Kind of. There's something called the Standard Contract Terms Directive in Europe, which under which some standard contract terms prohibited, and this kind of setting also applies if I, as a consumer, have a contract with MyRight. So I'm kind of protected.
Great, and I want to leave plenty of time for Victoria to have some rebuttal time and some time for questions, but I do want to pick up on one I want to poll the group on something that Susanna just said, which she said, we don't know what we don't know. We haven't seen a lot of the agreements, so we don't know the level of control. But I'm wondering if the rest of the panel agrees with Susanna's interpretation that we shouldn't be so naive to believe that there's not control. Is that shared by the panelists, that you all agree there is likely some level of control in all of these agreements?
Well, very quickly, we had a large paragraph exactly on that. So at least in 2020, we were very skeptical that there is a level of control fairly shared by those different actors. So, but again, we didn't have a lot of data. It was more like a feeling that we also saw in other B2B relationships, let's say.
I actually, I see this as a definitional question. So Tony has an excellent article on what do we talk about when we're talking about control, because there's different ways to define what we mean and what aspects of the case could be controlled. And so I think it would depend on what we're talking about. If we're talking about a funder going in and saying to the attorneys, this is how you should conduct the case, I think we probably would agree that that's not what we're looking for, unless the funder is a party, which could be the case if the funder has equity, which is one of the structures of funding that the definitions sometimes don't fully capture. But if it's, something like, let us know if you're about to settle so that we can take a look at the settlement agreement, that's different. And so I think it would depend on, what we mean when we're saying, using the term control.
I don't have any concrete empirical knowledge. I only have sort of formal reasoning. And if I were a consumer who was being virtually represented or represented as a matter of law by a professional organization negotiating on my behalf, and they could get a better price from me by giving up some control, I'd want them to do it.
Victoria, your time.
Sure. I'll just pick up on something that, everybody mentioned, Susanna, Kai, and Tony, which is this idea of trust and reputation. A large part of the funding industry growing to where it is now, and also where it will go in the future, is how much trust we place in parties to negotiate with their attorneys, attorneys to negotiate with the funders, funders to provide appropriate terms to parties, and trust of these consumer organizations that are bringing claims on behalf of large numbers of people. I also wonder about whether the trust and reputational aspects are transnational, right? So this is a industry that is not really bound by our borders. Yes, we have state regulation, and yes, there may be national regulation, and yet the big funders, definitely the ones represented in this room and the ones that are really driving the conversation in terms of regulating the industry, operate across all of these boundaries in many of these jurisdictions that may have conflicting ideas about how the funding industry should be constructed and regulated. And so there's a question about really, what does it mean to trust, and what information do we need in order to really fully feel like we can trust these industry players to be involved? I think we're getting more, right, as time goes on. Conferences like this and other ways in which the industry is becoming a little bit more transparent is really good. I think we still have some ways to go before there's enough information out there that there's a little bit more, okay, I understand what this is. I'm a little more okay with it, but generally speaking. And so I think this is a big question. One of the challenges of being in the shadows, so to speak, or not being as transparent, is that people assume there's a nefarious purpose, and that erodes essentially public trust. And so maybe to the extent that there is more transparency, the trust can be built up more. So that's something to consider.
Great. Well, we have 10 minutes left, and I can't see past this side. So if anyone wants to ask a question on that side, please just jump up and let us know. But for our 10 minutes, we'll take questions. If they run out, I'm sure that the panel can fill the rest of the time. But let's start here, and please identify yourself and your affiliation in your question.
Oh, you favor a disclosure rule? So my name is Keith Sharfin. I teach here at NYU and at St. John's. I'm sorry I missed the morning sessions, but my students, I was teaching them. So I enjoyed the panel very much, but I thought it was going to be a discussion about international regulation, which is how it's titled. But what I heard was really a discussion about the domestic law in various jurisdictions and comparative law. And I guess if I had been among you, what I would have wanted to talk about is whether cross-border transactions in TPLF are regulated, and if so, how. And I thought that the last comment by Victoria really went to that. My sense here, at least in the U.S., is that we're not regulating it at all on a federal level, but we are getting judges who are responding to kind of what I would regard as a sort of a phony argument about, oh, well, this might be, we have to have disclosure here because this might be funded by the Chinese and there's xenophobia towards China, or this might be getting funded by the Russians. And I thought, was it Mississippi? I forget which jurisdiction it was. I thought passed a very good rule that just said you could disclose whether there's international funding or not.
Louisiana.
Oh, Louisiana, I'm sorry, Louisiana. And without getting into any more detail than that. And that seems to me to be the way to go. But more generally, my thought would be that why don't we, for those who are sort of on my side of the debate here, I'm on Eric's side, which is in favor of not necessarily requiring disclosure. I would like to see an affirmative legislative agenda from that side. How about legislation that protects the privacy of TPLF? Because right now we're getting kind of proposed legislation to bust the privacy of TPLF. How about efforts by our trade negotiators to enforce international trade norms with respect to cross-border TPLF transactions? Why some of the stuff that Susanna was talking about from Germany and the EU suggests to me these are non-tariff barriers to trade in financial services. So I would want to go in the entirely different direction. I would want to see funders getting more access to more markets, because this is an important financial market that should not get blocked. If we have a problem with a particular type of tort action, let's reform tort law. Let's not regulate financial markets. So wonder what you all say.
Any responses?
Oh, go ahead, Tony.
No, just one word. Indiana prohibits certain transactions now because of the foreign quality of the funder. So that's going in the wrong direction for you.
And why should it be a state or federal judge rather than just some kind of agency?
So I'll just mention in the international context, so you asked the question about whether there's broader international regulation. One of the challenges in the sort of global context is we don't really have a regulator in the same way. We have the United Nations, which is not really a regulator, in some respects, it just can make suggestions. We have the United Nations Commissions on International Trade Law, UNCITRAL, which has working groups that look at funding, among other topics, in investor-state arbitration particularly, which is a subset of international arbitration. WTO is interesting because the WTO dispute settlement mechanism is quasi-adjudic. I mean, it's an interesting mechanism. There is funding that exists in that space. I think it's under-theorized and under-examined. So you raise a good point about the WTO. That's one we should definitely look more at. I think where the regulation is happening in the international context is international arbitration institutions. So there actually are a lot of disclosure rules in those spaces, and that's where the disputes come up in the cross-border context more often than not. And then the other place is in the investment treaties themselves, which is where there's some treaties now have disclosure rules for funding. They're newer treaties, of course. The older treaties don't have this. So it's really tough. This is one of the reasons why I've written about having a global code of conduct that we could potentially adopt, because it's very difficult to have real cross-border regulation because of the various sovereignty issues, as even just the EU itself can't tell all the member states itself what to do. I mean, let alone the whole world. So, so it's a really fascinating concept. And then to your point about trade negotiations and on behalf of the funding industry and having sort of confidentiality, I think that goes along with the trust and reputation question. I don't think anyone's going to want to protect the confidentiality of funding until they feel like they can trust the industry, and I don't think we're there yet. But it's a good thought.
I know we have just 4 minutes left and at least 2 questions on the floor. So if we can keep the questions concise, we can probably get to both of them. So
First of all, thanks so much. And just to piggyback on what Victoria was saying, Erica Levin, Fox Rothschild, in terms of the international context, a couple of variations that we need to consider, and you espoused a number of them, but I just wanted to highlight, and we can talk about it later because we're short on time, but I think it's important to recognize the systems are very different. And so as you're looking at Australia, UK, you name it, common law systems that in and of themselves are different, bearing in mind the civil law system, and again, I'm informed more by arbitration than the representative actions and the like, we have a different disclosure system. And as Victoria mentioned, institutions have been mandating things and the like, and one of the differences between the US common law and civil law system is discovery. So the advantage we saw in other jurisdictions of a disclosure was, oh, we wouldn't have gotten that information maybe otherwise. There is a funder involved, there is potentially merit, which I should add, we've come a long way because that was never the way things were looked at before, at least initially. The other thing we said, adverse costs, the ATE and insurance regime, that's important to keep in mind, right? And last, I leave you with just one more, is the distinction between the civil law system and common law system as it relates to champerty, barratry, maintenance, the ability in the civil law system to acquire claims in a different way. So there's so much. This is the beginning of maybe more talk for next time. But I just wanted to thank you for everything. And thank you to the center.
are there other questions in the audience? So I think one thing that I've learned listening to all of these, and I think the last question and comment points this out too, is that there may be parallel tracks on a lot of these things simply because there's not sort of a coordinated track available because of the distinctions between the two systems. And that's another definitional issue, right? Just to solve that. So why don't we take our last 2 minutes for each of you to just give a final thought for the audience, and while you're doing so, perhaps a projection of what's next. What should everyone be looking for most directly coming out of the EU, or from an international perspective? What should we all be keeping an eye on and looking for in terms of the next big thing? So let's go in reverse order and start with Tony and go backwards then. Sorry, Victoria. Victoria, you were last.
Well, thanks. So I'll just say, I'll reiterate my comment earlier, which I think the industry should find ways to fund the areas of the legal dispute settlement system that aren't currently funded because of the economics. I think that would be something I would encourage. And then the other thing I would say in terms of places to watch, I would watch UNCITRAL Working Group 3 on investor-state arbitration. That's essentially a multi-state effort at looking at reforming the investor-state arbitration system, where some of the big mega-funded cases are. If there is a rule that comes out of that and states start adopting it, I think you'll start to see some major legislative changes around the world as a result of that process. So that's one to watch.
Great, Tony.
So while there's this American smugness about the fact that the European or civil law systems are behind us when it comes to collective redress with no class actions, or they haven't really embraced class actions, I want to emphasize that they have actually, I think, a much more sophisticated approach to a number of issues that litigation finance is attempting to solve in America. So for example, the fact that it's much easier to assign a claim in Europe than in America, I think is important to look at, and I think we should emulate them. The fact that it's much easier to relinquish control over the handling of a claim in Europe than maybe in America is something we should look at as a model for us to emulate. A lot of our problems and arguments about TPLF are actually self-inflicted wounds, I think, because we have so few other ways of making meritorious claims reach the courts.
Susanna?
I'm very grateful for the two last points, or the same point made by two people in the audience about the international perspective, truly international. And I think besides the fact that we don't have an international regulator with the competence, there's also not really an international engagement. Like there are claims in different countries, funders active, the same funders are active in different countries and continents. But it's so difficult for the reasons mentioned to have, for example, even if you have a case like VW where you have basically the same fact patterns in different on different continents, to have like one dispute, because there's not even one court which could handle everything. So, but I think while in Europe we have not seen any class actions, and there will not be any class actions, we have the assignment models. They're not yet well established. I think I have a different view on this as you, Tony, but I think there will be more coming from this side. So maybe in the future we need some corporate governance rules on third-party litigation funding in an international setting. And what we have not touched upon at all is, for example, funding of public interest litigation. So maybe this is also an area to look for in the future.
Many more discussions to come. So we are past time, but
Yeah.
can I take our last 30 seconds?
Yes, thank you. So maybe to conclude with something positive. I think European industry was so scared about a class action wave and so on, that indeed certain companies, we talk now about Ryanair, are still not there yet. But a lot of others have actually, because they were so scared, now included some internal redress mechanisms. So it's often very, very easy in digital means to claim, for example, for redress because the Deutsche Bahn is again too late, over 2 hours and so on. So I think, again, this is at least a nice side effect of the whole debate. How it's now continuing to play out with legislation, as we said at the very beginning, remains to be seen. The study, you will see it on LinkedIn probably, in December. Many people are waiting for it. And then, as I also said, hopefully it's becoming part of a larger political discussions about enforcing of rights, how class action or representative action can help with that, and so on. But right now, I think not even the Commission has a clear position.
This is a critically important discussion. I applaud NYU and the Center for putting this together, because I think, as you can see, there's so much that can be discussed. And I also applaud our panelists who brought such a wonderful perspective to that overall discussion. So, well done.
Thank you so much to the panelists from this panel, from all the panels. Thank you all for being here. What a wonderful event. We're so lucky to have had you all here. I want to give some special thank yous to Eric Schuller for conceiving of this, doing so much work in making this happen. Members of the Dispute Financing Library Board who have done so much work in the Center on Civil Justice for so long on this issue. Erica Levin, Maya Steinitz, Tony Seebach, Victoria Sahani are all here. And of course, Eric. Also, thank you, Kai, for traveling across the Atlantic to be here. Thank you, Assemblymember Magnarelli, for coming almost as far from Syracuse. And really, thank you, everybody. The one thing I want to say substantively that I think is really important about what we did here, and hopefully will continue to be done, is there's sort of two sorts of bringing people together that happen. One is bringing people who disagreed with each other together to be in the same room. I think this was mentioned by both Eric and Janet at the beginning, but so easy to get siloed on these issues. And it's only when I hear people starting to get annoyed at each other that I start to think about new things that I hadn't thought about before. So I thought that was really important for me. And also bringing together academics and practitioners and regulators, legislators, policymakers. Having all three groups of people in the same space, I think, is really important, because the same way you get siloed on an issue, you sort of get siloed with your own type. And academics start talking to each other, and policymakers start talking to each other, and practitioners start talking to each other, and they don't interact. And so I loved seeing that sort of interaction today. So thank you, everyone. A couple quick housekeeping notes. One is we did record this event. It will be online. It will take a little bit of time because you have to subtitle it for accessibility. Second housekeeping note, if you want CLE, remember to sign out when you leave. And the last very quick thing is that the next third-party funding event that you may want to attend will be here at NYU on November 21st, across the way in Furman Hall, 12 p.m. to 2 p.m. It's third-party litigation through a transatlantic lens, and Susanna Augenhofer's been organizing that and done an amazing job. So hopefully we'll see you either in person or I think it's online too, right? Oh. On November 21st at noon. And thank you so much for coming. Really appreciate it, everybody.
Thank you.